My next guest is Professor Greg Rose, who is a professor of international law at the University of Wollongong and also a visiting fellow of the Australian-Israel Jewish Affairs Council. Welcome, Greg.
Thank you very much for inviting me onto your program, David. It's a pleasure to be here again.
And it's very good to have you on the program, because the last time you were speaking was about the International Criminal Court, and now we have an opinion of the International Court of Justice, which came out recently. I wonder if you could explain to us what the courts are and also the circumstances of the release of the ruling. So perhaps we could begin with your explanation to us of the difference between the two courts.
Certainly. Well, they have a similarity in that they're both in The Hague, and the Netherlands positions The Hague, its capital, as the seat of global justice. And the International Criminal Court is established under a treaty called the Rome Statute, and parties to that treaty are parties to the International Criminal Court and take on obligations to cooperate with it. And in contrast, the International Court of Justice is established under the UN Charter. It is a creature of the Charter, one of the 6 fundamental organs of the United Nations, and the statute of the court is at the back of the UN Charter, and at the back of the statute is an optional protocol that states can ratify and submit themselves to the jurisdiction of the court. So in fact, they have a similarity also in that it's a matter of sovereign consent to participate in either court by signing the Rome Statute or by signing the optional protocol to the statute of the International Court of Justice in the UN Charter. In actual fact, a minority of states have signed on to the optional protocol in the Charter. Australia, for example, signed on and fully submitted itself to the jurisdiction of the International Court of Justice. I'll call it the ICJ, but lodged some reservation in connection with maritime boundary delimitation cases in the context of our dispute with East Timor. And similarly, Canada, when it had maritime disputes concerning the Grand Banks fisheries, where the fish overlapped the high seas and the Canadian waters, it also, although it had previously fully submitted to the court, it reserved, you can give a reservation with 12 months' notice. So the International Court deals with states and with comparably, one could call them civil disputes between states that they voluntarily consent to have resolved by the court. This is called its contentious jurisdiction. And the International Criminal Court, on the other hand, deals with criminal matters, which don't occur at all in the ICJ. And criminal matters relate to individuals. So an individual may be the head of a state, but is charged with a crime as an individual.
Yes. So what we have here is an opinion of the International Court of Justice, and therefore it's not binding on anybody. Is that correct?
So I referred to the contentious jurisdiction, where you have a dispute between states in the ICJ, and the other jurisdiction it has is its advisory jurisdiction, where it can give an opinion when requested by a UN body to clarify matters concerning administration, superannuation, sort of the legal internal effects, but actually drawing limits on the scope of the opinions that can be given has proved impossible. So its advisory jurisdiction has been mobilized in international disputes, as we see in the case that currently the court decided on Friday its advisory opinion against Israel, where UN General Assembly states mobilized the advisory jurisdiction of the court as part of a lawfare strategy against Israel.
And what essentially, in a brief summary, was the opinion?
I didn't fully answer your previous question as to whether it's legally binding, because it's not in a resolving a dispute and setting a judgment between parties. It's giving advice to the UN. So that advice sets out the court's opinion on the law. So it doesn't actually bind the parties because there are no parties, but in fact, it still has great authority from the principal judicial organ of the United Nations pronouncing on what the law is.
But many of these judges on the court are appointed by dictatorial regimes, and they don't seem to observe the usual requirements of diplomatic or judicial propriety. They are quite often the sort of people who we would never appoint as judges. Is that a fair assessment?
It's true of some, but not of most.
Not all. All great powers. Normally, each great power has a judge, though I don't think the British do at the moment. Is that right?
That's right. They got bumped in about 2012 in favour of India. And the points about judicial propriety, integrity, expertise in international law, the criticism that you make is valid, but not in relation to all judges. So usually a majority of judges are diplomats from the foreign ministry. They carry forward the foreign relations policy of their government, which is political. So in a lot of matters, international law deals with political issues. In many, it deals with technical legal issues, but when it's dealing with political issues, those from foreign ministries generally follow their government's policy. The other place that judges tend to come from is academia. So, for example, judges from Japan, Germany, Australia, Brazil, the US, Romania, at the moment, those on the bench are from academia. And then occasionally you have judges, people who are experienced as judges from their national courts now sitting on international matters, as is the case for India and Uganda.
And just very briefly, what was their advice on Israel related to the so-called occupied territories? Did it not?
Absolutely. Essentially, the court came up with a decision that was one-sided, artificial, impracticable, and imposed on Israel, on its society, its military, and its economy, impossible burdens. It called for ethnic cleansing of Jews from the West Bank, otherwise known as Judea and Samaria, including from East Jerusalem, and for compensation to be paid to Palestinians and for the establishment of full Palestinian self-determination in the areas to be evacuated, Gaza, West Bank and Jerusalem.
Yes, well, there was a report in The Guardian that the Australian government said that Australian government source said the ICJ ruling cannot be ignored. This was the ruling that the continued Israeli occupation of territory seized in 1967 was illegal. But this goes against, does it not, the whole basis of the establishment of Israel as a mandate?
You've raised several issues there to unpack, David. So the first thing is it won't be ignored. It was intended as an instrument of political utility, extending the battlefield from the ground to the judiciary, and it gives a green light to sanctions and boycotting of Israel, which will endanger Israeli supply lines, security, and so on. It also gives a red light to negotiations because it effectively says we endorse the maximalist positions of the most extreme Arab claims that, for example, the Palestinian state must be contiguous, which is Gaza, West Bank and Jerusalem, which suggests a an overriding of Israel's own territory. It seems almost to revert to the situation before 1967, when in fact that land was under Jordanian, in particular, but also Egyptian occupation. And it calls for ethnic cleansing, basically, of Jews from all of those areas.
The very
I think
term,
the consequence...
if I interview, the very term occupied territories is wrong in law, is it not?
Well, there are certainly disputes. The majority of the court concluded that the entirety of these areas are occupied, but one can't occupy one's own territory, and Israel has valid sovereign claims to those territories that it has always been willing to negotiate in exchange for peace. But due to the absolutist and maximalist Arab claims, there's been a refusal to negotiate peace. The closest that we came was the Oslo Accords, 1994 and onwards, which were considered by Arafat and the PLO to be first steps towards the elimination of Israel. So the judgment will not be ignored. It will be utilized by anti-Israel forces, amongst whom I include the current Australian government. Penny Wong has been absolutely adamant in her criticism and attacks on the Jewish state. And it's an issue which serves as a wedge between political blocs. So the Jewish state and protection of Jews is, in a sense, a wedge issue between Labor and Liberals in Australia, Democrats and Republicans in the United States, between Western liberal international countries as a bloc, and the alliance of China, Russia, Iran. And in that constellation, our government will choose to rest upon the ICJ judgment to take actions against Israel.
Well, the Australian government has demonstrated its complete bias against Israel by calling in the ambassador and dressing the ambassador down for Israel daring to consider defending itself against the various attacks by Hezbollah from the Lebanon. Now, that seemed to me to be extraordinary, that you'd call in an ambassador and tell the ambassador, don't dare defend yourself, just put up with those attacks, with all those rocket attacks and drone attacks on your state, because we won't support you if you defend yourself. And I can just imagine how Australia would feel, or would have felt, for example, in the Second World War, if a friendly country had called in the Australian ambassador and said, well, we're telling you, don't defend yourself. Japan is invading your territory and bombing Darwin, but don't you dare do anything about it because we won't support you.
Well, what you point to really is the flip side answer to your question about the impact of this judgment. So it will also be ignored, because the command to commit suicide that's embedded in the judgment will not be obeyed.
You also mentioned to me while we were talking the way in which the court released the judgment at a time when they thought they would disadvantage the Israeli government.
Well, there seems to be a practice that has grown in the UN of releasing controversial legal documents just prior to holidays, or in particular Jewish holidays, so as to prevent blowback. This was read at from 3 to 4 o'clock on a Friday afternoon just before the Jewish Sabbath in The Hague, and the timing was just before Israeli Prime Minister Benjamin Netanyahu's address to Congress. So it was intended to spike his address to Congress by raising criticism and delegitimizing him and his credibility, and the credibility of Israel's case. But fate intervened, because the CrowdStrike computer crash occurred at the same time that the judgment was being read out. And that became the news story. And when it was being resolved, President Joe Biden announced he was no longer going to run as candidate for president. And that became the next news top-level story, thus pushing down the ICJ judgment and reducing its impact on Benjamin Netanyahu's address to Congress.
Providence seems to have intervened in those circumstances, as Providence did on other occasions. But one of the things that seemed to me to be appalling is that when Prime Minister Netanyahu addresses the joint meeting of Congress, the person who should be presiding, whose honour it is to preside, whose duty it is to preside, Kamala Harris, seems to have another appointment. I thought that was an extraordinary act of rudeness on the part of the Vice President.
Well, I suppose this does take us a little beyond my international law expertise, but it can be simply described as the horseshoe effect, where you have the left, and in this sense, perhaps Kamala Harris is deferring to the extreme left of the Democratic Party, and that horseshoe meets with the fascist right, where it curves around on its extreme. So you have an alliance between the far left and the Islamo-fascist right, where they have common points of interest, such as using the Jewish state as a wedge issue with which to attack the central bloc of democracy and democratic countries. Yes, we have the alliance between the Greens in Australia and the anti-Israel movement. They're one and the same in their hatred of Israel and use of it as a tool against government.
Before I came in today, at the time of recording, I noticed there was a piece in the Australian by a man called Baker from, I think, one of the American, might have been the Wall Street Journal, republished in there. And they said that the Biden administration was looking at following a different policy, not following the Obama policy of appeasing Iran, and also following the Trump policy of the Abraham Accords. I wonder if you noticed that.
I haven't seen the article, but certainly the Obama policy of appeasement of Iran was misconceived, and the same people who are the architects of that policy under the Obama administration are the people who determine Iran policy under the Biden administration. So in fact, it's Obama Redux regarding Iran currently, and that will change if there is a second Trump administration, because under the Trump administration, there were very tight sanctions imposed upon Iran. The Australian sanctions regime is far behind, inadequate, and needs significant strengthening in order to be anything more than shameful window dressing.
Well, I think you've explained very clearly to us that the International Court of Justice is a different court and that this is an advisory opinion. We saw, viewers will have seen the President of the International Court of Justice reading that opinion, but he himself has a very strong political position in relation to Israel over many years, has he not?
Yes, the statute of the International Court of Justice sets out that a person may not preside on a case in which they have been previously involved. And he has condemned Israel 210 times on the public record as Lebanon's ambassador to the UN. He's run twice for Prime Minister of Lebanon. He refused to recuse himself on this case and pushed it forward at speed in order to achieve a judgment that would condemn Israel, although he clearly is open to a reasonable apprehension of his bias. But this is the International Court of Justice. Yes. It is a political organ. It's not actually a legal body that has the usual guarantees of integrity. In the 2004 International Court of Justice judgment against Israel, also an advisory opinion mobilized again by the General Assembly in order to condemn the separation barrier, which was protecting lives within Israel from suicide bombings on buses and infiltrations and stabbings and so on. Two of the judges should have been recused, Al-Qasone and Al-Arabi, both of whom were previously prime ministers, foreign ministers, head of the Arab League, engaged in political activism against the state of Israel that was the subject of the opinion. So the court is certainly not one that meets the standards of a modern Western court when it comes to judicial integrity and guarantees of the rule of law. In fact, the rule of law is ridden over roughshod, as is made very clear in the strong dissenting opinion of Judge Sebutinda, Julia Sebutinda from Uganda, who gave the sole judgment dissenting from pretty much everything, apart from the ability to take jurisdiction in the court's judgment.
It seems to me, and I've thought this for some time, that we've probably gone too quickly into having international judicial bodies, and whenever there is a genuine legal dispute between two states, and they are willing to settle it according to international law, and they're not always willing to do that, but if they're willing to settle it according to international law, the better thing seems to be to appoint an ad hoc arbitral tribunal of excellent international lawyers to determine how international law applies in that dispute. Is that a reactionary approach, or do you think that's a realistic approach to international law at the present time of the development of international law?
I think it's quite realistic and sensible suggestion, and arbitration has been used for over a century. Both the Permanent Court of Arbitration and the Permanent Court of International Justice are located in the building where the ICJ is currently situated in The Hague. And arbitration gives states more control over a dispute, the terms on which it's decided subject to their consent, which is the premise of international dispute resolution under classical international law. That position is challenged by the structuralists who want to build institutions that have separate authority from states. And the court is, and lawyers on the court, the judges are advocates of a more institutionalist structural approach, because of course that gives them greater agency and power and ability to affect the course of international relations in the world. But once that's overreached, the judges are burning down their own house. And I think that this judgment is particularly bad. It's an inflection point in the international legal system, which is a signpost on the road to an international law wasteland. I think this judgment ultimately damages the court by overreach.
So before you go, is it fair to say then, as I think the conclusion is, that the original inhabitants of this part of the world are the Jewish people who've been there before anybody else, certainly before the Arabs came with the rise of Islam, and it's fair to say that this was part of the Ottoman Empire until the end of the First World War. It then became a British mandate, and Israel is the successor to the whole of the British mandate, including the territories known as the West Bank, or Judea and Samaria. The word Judea is avoided, obviously, by those who feel they wish to hide the fact that this was originally a Jewish-owned area, and it's referred to as the West Bank, and Jerusalem, of course, is the capital. All of these are part of the territory of Israel. Israel couldn't possibly be occupying its own territory. Is that a reasonable conclusion?
That is the correct traditional legal black law conclusion to draw. Judea and Samaria were called that under the Ottomans and under the British Mandate. They were only called the West Bank by Jordan when it occupied it and crossed the Jordan River in an aggressive war and a military or ultimately annexation of that area. But the West Bank language and term is still used in the international community in order to sanitize or launder the fact that the area was previously indigenous to the Jewish people. Indigeneity is marked by the formation of national myths and history, sacred places, identification of cultural monuments and history with places in the land, the formation of the language, the culture, the festivals, seasonal observances. So the Jewish people have all of that in that place. So that is the land to which they are indigenous. But you won't find any of that in the ICJ judgment. It carefully ignored discussion of any Jewish claims, any Jewish history, any Jewish self-defense, any Jewish security risks in the context of the attacks on Israel, of which the court is a tragic and disgraceful part.
Professor Greg Rose, thank you so much for clarifying the true position in relation to this opinion of the International Court of Justice. Thank you.
Thank you, David.